Hey, I'm Vishnu Srinivas, and you're listening to the Hawkeye podcast. Joining me today is Professor Katharina Pistor. She is a professor of comparative law at Columbia Law School. Thank you so much for taking the time to speak with me today.
I am really delighted to be on your show today.
Awesome. So would you like to give a short introduction about your background and role?
Yes, so I have been teaching at Columbia Law School for a little over 20 years. I got my legal education actually in Germany, but I've been teaching mostly in the United States, first at the Kennedy School of Government at Harvard, and since 2001 at Columbia Law School, where I teach corporations law, so general introduction to corporations, seminars on law and finance, a class on law and development.
Awesome. Yeah. So let's kind of dive into something that you've really talked a lot about and written a lot about, and that's kind of the role that law plays in inequality. And I guess give us like a high level background. How does a seemingly systematic code create so many discrepancies in the people that it affects?
So let me first say that maybe there is no such a thing like a systematic code, right? So in the book, The Code of Capital, How the Law Creates Wealth and Inequality, I talk about the code more in the sense of a genetic code or maybe a software code, where we can use different modules, I call it, of the legal system and combine and recombine them in such a way that we can create private wealth. So there has never been like a grand design of a legal system. That's not how law evolves. Law evolves in different ways. Sometimes legislatures make law, but very often in response to what already is being practiced or maybe problems that they see in how things are happening on the ground. But a lot of law is also created by people adopting certain practices and then at some point getting them vindicated by a court of law or getting the legislature to endorse them. So we have a complicated patchwork of law. And what I'm arguing in the Code of Capital is that a certain handful of legal institutions, standard private law, such as property rights, contract law, corporate law, the law of trust, the common law trust, collateral law, which is secured interest law, as well as bankruptcy law, have been used for over 400 years to code very different types of assets as capital. Land, for example, firms, debt, know-how, ideas, you could add data to it, you can add even nature to that. And I'm basically showing how mostly private attorneys code these assets and that give then the asset holders a comparative advantage over others. So as long as you can code something in the law, and you basically click certain boxes where judges or law enforcers or also legislators think, oh, that's legal, because it looks like it's legal, right? Because you have made it look exactly like what we've done before, then you can almost predict that this will be enforceable in a court of law and you can use it to your own advantage.
And that's a really fascinating point because you come across terms like legal arbitrage, and it almost seems oxymoronic in that like we've commodified the law in that like we're in control of it rather than it governing us. Is that kind of like a fair assessment of where it's headed?
I think that's a fair assessment as to where we are. I think we have struck the balance slightly differently at different moments in time. So let me just say at a very fundamental level, we can't avoid legal arbitrage for the simple reason that law is fundamentally incomplete. Right? Economists have long argued that or discovered at some point that contracts are incomplete, that not two parties can not possibly anticipate all future contingencies and provide for them in a contract. Now, if that's true for two parties in a contract for a simple transaction, it of course has to be true as well for a legal system, right? Which is designed to cover many different types of transactions and is also designed to last for decades, if not centuries, right? So much of the law that we carry around has been with us for centuries. So it has to be incomplete. Otherwise, we would have to rewrite it all the time. Once you recognize it's incomplete, you also know that you can arbitrage around it. You can pack it with lots of different meaning. And even if sometimes regulators come in and say, we want to sort of, just stop certain activities, sometimes they use very specific rules, but then they only cover the specific rules. And then you find ways again to get around it. So one lawyer I've been teaching with for quite some time, who's a practicing lawyer, she tells my students always, you have to think about the legal system, including the regulatory system, the private law system, like a scaffolding around a building. And if you want to do something new for your client, you want to make sure that you don't hit the scaffolding, because then it's going to be illegal and you won't be able to enforce it. But you want to find something that fits through the gaps of the scaffolding. So that's a strategic move of understanding where the gaps are so that you claim it's legal even if you're violating the purpose of the law. And in a system that is increasingly governed by law and regulated by law, being able to manipulate the legal system is one of the most important sources of value. So if you hire the best lawyers and you have the resources to hire the best lawyers, you have a comparative advantage over others.
Absolutely. So when we look at kind of a real life example of the distribution of capital, and look at like the COVID recovery plans that were put in place, for instance, do you feel like there were certain parties that benefited more maybe unfairly more than others at the expense, obviously, of others?
Yeah, so the COVID crisis is an interesting example because here the government basically said we want to, open the floodgates of publicly issued money and give it to lots of people so they survive the COVID crisis, right? So typically we say you somehow have to make your money yourself. We only allow banks to use the government franchise if you want and create their own money, right? But now the government says we want to support everybody. And then the question is, this is basically a direct subsidy on a massive scale. And the question is who got it? You saw, of course, everything from fraud, misrepresentation, to sometimes just being really well positioned to get things. And that has a lot to do with, I think, the way we have reconfigured our institutions, legal system, administrative system over decades, because the belief that the market's the best place in allocating resources has also meant that we have disinvested in government institutions and infrastructure to reach people. So when we want to give people money, how do we do this? One of the big issues was, how do we reach households or small and medium-sized enterprises? Well, they don't have an account with the Fed, right? So we said, well, we'll use the banks, but not everybody has an account with the bank. If you don't have an account with the bank, you don't get that money, right? Or you do it through the IRS, but then you must be able to pay taxes. Not everybody's paying taxes or makes enough income even to pay taxes. Others, of course, avoid it. So I think if we think systematically about whether the state can reach people just in a normal subsidy fashion, it's not fundamentally different from what I talk about in the book, because we have basically outsourced so much to the private sector that even in a crisis, the government has a hard time to reach everybody and provide for everybody. It does it through middlemen, and the middlemen take a lot of the cut. And so again, you have increased inequality. And you can see this just by by basically looking at what the returns were, the profits were that companies were making during the crisis.
Right. So I guess in an effort to make this process kind of more transparent, could you talk about, maybe from a corporation's perspective, if a government introduces new legislation on, let's say, emission standards, which they've been doing seemingly for a long time, how does an oil company continue to get away with maybe not complying with these standards?
Yeah, so these are, oil companies, it could be car companies. So there are lots of things that governments, I think you have to unpack a little bit. When we talk about the government, there's not a single government that we're talking about, right? So we have a federal system in the United States and we have a global system. And we also have put rules in place that make it easier for companies to migrate. And companies don't need passports and visas to migrate, because we basically have said, most countries have said that they will recognize a corporation from other jurisdictions. So corporations are legal creatures. So they're created in a particular law, but most other legal systems say, we will nonetheless also recognize you as a creature, even if you just take another law. So one thing that happens a lot, companies set up subsidiaries in the Cayman Islands, right? Because it's a tax paradise. And then the United States or Germany or France and the UK, they all recognize these corporations, even though they know that they don't have employees. They all have the same boards because there's a couple of folks in the Cayman Island that sits on these boards. The only reason that these things exist is for tax sheltering and tax avoidance, if not evasion, right? So one way to get around rules is just to say, we locate some of our accounts, or not really activities, but just the accounts really through a different entity that we create in a different jurisdiction, where we get better advantages. Coming back to your emission standards, it can really cut both ways, kind of interesting. So there's, of course, always a lot of lobbying against such standards as well. So that's part of the political economy. But sometimes some jurisdictions, let's say California, are more rigorous in trying to impose emission standards. And if California does it, then typically Detroit, where the cars are manufactured, listens, because they won't be able to sell cars in California if they don't comply with these emission standards. So this is like the California effect. A colleague of mine, Andrew Bradford, has written a book about the Brussels effect. Brussels can do something similar sometimes. So regulators sometimes can be quite effective if they can regulate large markets and do this effectively, right? But at the same time, powerful companies, like let's say the oil extracting companies that you were talking about, they can also try to get around many rules by relocating headquarters. Just think about Shell Corporation, Royal Dutch Shell, it was called. It's now moving entirely to the UK. And that has a lot to do because I think with two things. One is a tax regime in the Netherlands that makes it harder for Royal to dole out profits to its shareholders. And another reason is that the Dutch courts have increasingly held Shell liable for subsidiaries in Nigeria and elsewhere polluting the waters. So they just moved their headquarters to another jurisdiction, and so they can get around some of the restrictions that courts want to impose. So the mobility of corporations and the ability to pick and choose the laws by which they wish to be governed is one of the most powerful devices that corporations have. They don't have to have that. We created this, right? You and I can't just pick and choose the laws by which we wish to be governed, right? But corporations can, and I think that's a problem.
Yeah, it seems that like governments are aware of the, I guess, the doings of these corporations, but I guess there's just a relative lack of action on their part. Which I guess it brings me to my last question. Obviously we still need legislation in place, but I guess how would you go about like fortifying or making this legislation more robust to prevent loopholes where corporations can like circumvent it in unfair ways?
Yeah, I think a diagnosis of the problem is important before we do something. So I think one of my diagnoses to say that the migration, the picking and choosing, is a powerful tool for holders of capital and their coders, the lawyers that help them with doing that. And so my advice would be to say we have to sort of shrink the scope of activities where they can simply pick and choose, and we have to look over their shoulders whether they did this just for evasion reasons or avoidance reasons, of whether it's regulations or taxes. So, if just, let's say, the state of New York enacts a new law, well, people will migrate to Delaware, right? If the federal government does it, we might have a better control. For example, there have been proposals by Senator Warren and others to suggest that we should have a federal corporate statute. In the US, it's all state-based, which gives you more flexibility. So for the biggest corporations, she and Bernie Sanders suggest that we should have a federal statute. No, it's not going to pass. It's not going to pass, right? We know that. So given that we won't be able to do this politically unless we have, a very different political representation in Congress, I think we have to think about how other jurisdictions gain greater control over either allowing corporations to come and do whatever they want to do, even if they don't wish to be governed by their own law. And it's up for them to basically create bigger or higher entry barriers, I would say.
Awesome point. Really appreciate you taking the time today to speak with me, Professor Pistor. Thank you so much.
Thank you for having me. Have a wonderful day.